No,
It's being
it's
taped.
okay.
We've got to see it.
Yeah, Richard, speed it up and
Can I
get
restart the
high
whole thing?
What?
Brian, shut up.
Can you what?
Hands up, you guys.
Restart?
Well, redo this witness. I knew time, so I
Can we-
just checked off some things. And, yeah, that's-
Another night at Strasbourg?
Go ahead.
Can I restart this one?
Your Honor, can the prosecution maybe ask for a time limit, seeing that they've already gone past their limit? 1 minute?
What's the
Hit
question,
the
Sean?
highlights, Richard. You don't even need your notes.
Just like you're doing Wednesday night. Just like you're
Why did you shoot Mr. Smith?
Because I was enduring my life for self-defense.
What happened after? What happened after Mr. Smith's party dropped their arms?
Well, Mr. Smith angrily informed me that I had to start paying the minor's tax off, and I asked to summon the sheriff.
Objection, Your Honor. The witness is being narrated.
Overruled.
He just informed me of the minor's tax act and how to pay it.
And what happened after that?
Objection, Your Honor. Never mind, I withdraw the objection.
Ask another question.
What happened after that?
Mr. Smith's left hand quickly darted, and I shot in fear of my life in self-defense.
Now, did you know if they were unarmed?
No, I didn't know if they were fully unarmed.
Could you see Mr. Smith clearly?
Yes.
Are you sure he moved his hand?
Yes, or I'd have to shoot his horse's head.
What did you observe in Mr. Smith's behavior prior to the shooting?
He was very angry and hostile.
Was there any alternative to shooting him?
No, there was not enough time.
How close were you with Mr. Smith's party?
Approximately 15 feet away.
What's next? Are you finished?
No further questions.
Mr. Cornell, you did shoot Christopher Smith of your own volition, didn't you?
Yes, I shot in self-defense for fear of my life.
Objection, Your Honor.
Your Honor.
The witness, excuse me, the witness just said in self-defense, and that calls for a legal conclusion. I asked that that be stricken from the record. He has...
I think he was explaining his answer.
Okay.
Good objection.
You did fight for Mexico against the American Army in the Mexican-American War, didn't you?
Yes, I did.
When you entered Dolores Peterson's mercantile in late January 1851, you did say a person has the right to do whatever is necessary to protect what belongs to him, didn't you?
Yes, that is true. Man, does I do.
And didn't you also say that she should not tell anyone that you had come in for supplies if she knew what was good for her?
Yes, I did not want to endanger Dolores in
Thank
any
you.
way.
Mr. Corner. Your Honor, may I approach the witness? Is this an accurate rendition of the ravine in which the incident took place?
Yes, it is.
And is this the boulder that you were hiding behind before you confronted these four men?
It was one of the many boulders that were there.
Is this the boulder that you were hiding behind?
It's not the specifics of there were many boulders there. There are many boulders in that area, as you can obviously see that there are many boulders in that area.
Answer, I don't know, or yes. or no? Is the one depicted in the
Your Honor,
diagram,
there were many boulders there at that time. That was one of the many, yes.
is that the one you were behind?
That was one of the many, Your Honor.
So you were hiding behind boulders before you confronted them, right?
Yes, we took a defensive behind the boulders.
You then, with your guns pointed at them, stepped out into their pathway and ordered them to disarm, did you
Objection,
not?
our counsel leading the witness.
I'm allowed.
In 2 years, you haven't learned that?
Please answer the
Overruled.
question.
Please restate the question.
Isn't it also true that you then stepped out into their pathway with your guns pointed at them?
Yes, because they were
And then you
armed.
ordered them to disarm, didn't you?
No, we asked them to drop their weapons, and they did so. They didn't have to.
You
but
did
they
this
did.
while
Objection, Your Honor,
you
this
were
line of
pointing their
question
guns
is
at
quite
them,
vague.
didn't
You
you?
keep saying they. It's never been established who they are.
Please restate your question.
Are you hard of hearing,
Yes.
Mr. Barnett? Isn't it true that you asked them to disarm while you were pointing your rifles at them?
Yes, they had rifles also there.
And then they disarmed, didn't
Well,
they?
they dropped their weapons as I asked. They didn't have to, but they did so.
Thank you, Mr. Corder.
Mr. Attorney.
When informed of the minor's tax by Percifer Smith, you did say that you were not a foreigner, didn't you?
Yes, I'm not a foreigner underneath the Treaty of Guadalupe.
Objection, Your Honor. Witness response lacks foundation. It's never been established what the Treaty of Guadalupe Hidalgo was.
He's under cross-examination. It can be asked.
You are a Mexican citizen, aren't you?
Correct, I elected to remain of Mexican heritage underneath the Treaty of Guadalupe.
Did Mr. Smith ever directly ask you to hand over to him $20 as payment for the tax?
No, not to him, but he did say that I had to start paying today, starting today.
Objection, Your Honor. I move that the that the witness's testimony be stricken on the basis that it goes beyond the scope of the fact.
Your Honor, may I respond?
Is it in his statement that says that? Or somebody
It's
else?
nowhere. It's not even in there at all.
Your Honor, may I respond?
No, I'll take under submission. I think I've seen it. Go ahead. You want to make a question?
Did you ever see Percifer Smith with a pistol at any time during the conflict?
No, I didn't have time.
Did you verbally warn Percifer Smith not to move his hand before you shot him?
Continue.
Yes, good job.
You didn't verbally warn Percifer Smith not to move his hand before you shot him, did you?
No, there was not enough time.
All right. And you redirect?
Yes, Your Honor. Why did you take a defensive behind the boulders?
We didn't know how many men there were in this party.
Calling attention to when you said to Ms. Peterson not to tell anyone that you had come in. What did you mean by this?
She's a good friend of mine. I didn't want to endanger her life because there were many hostilities to Mexicans, and if she was found out that she was selling supplies, it might endanger her.
Objection, Your Honor. The witness is creating material fact which is not in the record. I ask that it be stricken from the record.
Sean, we saw that tape
The last
today.
part will be.
Isn't
That's
it,
another question.
isn't it supposed to be noted? Because she keeps responding to it's not in the fact pattern, but it can be safely assumed by him, by his testimony, that this is what he wants. If this is a statement, it can be judged by many people in many different ways.
Burgers. Tony.
All right. Ask another question.
All right. Did you want to hurt Mr. Smith at the time of the incident?
No.
Do you hate Americans?
No.
No further questions.
Something else? Any other witnesses?
No, Your Honor, that was the defense. What do you say? Rest.
Counsel wish to argue? All right, let's have quiet. Speaking, quiet.
Who's timing? How much time did Sean's opening take?
Well, you have 4 minutes and 64 seconds left.
How many?
You have about 6 and a
Yeah,
half
6
minutes.
minutes, 48.
Your Honor, ladies and gentlemen of the jury, my name is Josh Dicker. I am a prosecuting attorney representing the people of the state of California in this case. We have proved beyond a reasonable doubt that Antonio Coronel is guilty of an assault with a deadly weapon. I would like to remind you that we must prove Coronel's guilt beyond a reasonable doubt, not a mere possible or imaginary doubt, because all aspects of human affairs are subject to possible doubt. You can expect 2 explanations of the events of February 10th, 1851. The defense will give you their explanation, and I will give you the people's explanation. You, the jury, must choose which is the more reasonable. We have met our burden of proof by showing that Antonio Coronel did freely and consciously shoot Percifer Smith and therefore exhibit his intent to commit the crime. Furthermore, we have proved beyond a reasonable doubt that Antonio Coronel did not have considerable provocation and that he did subject Percifer Smith to a high risk of death or serious bodily injury. The facts clearly show that Coronel did not shoot Percifer Smith in self-defense. The judge will instruct you that to raise the plea of self-defense, the defense had to clearly show that Antonio Coronel was in actual and immediate danger. They have not done so. I will now review the witness's testimony. The defense presented Augustine Janssens, longtime friend of Antonio Coronel. Mr. Janssens adds nothing whatsoever to the defense's case. He is obviously a biased witness. What does he add to this case? He has not seen Mr. Janssens in 2 years. He has not seen Mr. Coronel in 2 years. He can't even truly testify to his character. He doesn't know the man, although he was friends with him before this. Mr. Janssens also would lose his home and a valuable source of income if Mr. Coronel was convicted as charged. But more important than his bias in favor of the defendant is his complete ignorance of the events leading up to the crime and the crime itself. He admitted that he did not see what was being shot because he knew he would be caught in a blatant lie if he did not. He testified that Coronel is normally a reasonable man, but Coronel was not a reasonable man on February 10th at 4:20 p.m. Less than 2 weeks prior to the shooting, Antonio Coronel entered Dolores Peterson's mercantile. He was very secretive and bitter. He told her that a person has the right to do whatever, I repeat, whatever is necessary to protect what belongs to him. He even went as far as threatening Mrs. Peterson, an old friend. Mr. Coronel is not someone with a good character. The defense presented Jonathan Edwards. The defense would have you believe that Mr. Edwards is impartial. He is not. He is a writer looking for adventure, looking for a story. And he perhaps would have an enhanced outlook of the events on February 10th. Furthermore, he is biased against Percifer Smith. They did not get along. Edwards saw Smith with a pistol on the way to Coronel's camp. He never saw it afterwards. The defense would like you to infer from this that Coronel had a reasonable belief that Smith had a pistol on his person. Now, how can you believe that this is reasonable? Because Coronel did not have the same insight that Edwards did because they were not with, because Coronel was not with Percifer Smith earlier that day. Jonathan Edwards was not in the position to know whether Percifer Smith made any potentially dangerous moves. You will note that at the time, Edwards was on Smith's right side, yet the defense would like you to believe that Edwards saw where his left hand went. His view was obviously blocked by the horse. The only person who testified to Coronel's use of self-defense was Coronel himself. Ladies and gentlemen, are you going to trust a person who told Smith and his posse that he was not a foreigner, but later admitted that he was a Mexican citizen? Are you going to trust a man... Oh, I forgot, I'm not saying that. Mr. Antonio Coronel waited in hiding in the ravine. The judge will instruct you that if it appears that the conflict was in any way premeditated by the defendant, the self-defense plea may not be used. Mr. Antonio Coronel voluntarily entered. He did not avoid an unlawful conflict. The judge will also instruct you that when one does this, according to the common law doctrine, one assumes criminal responsibility. The common law doctrine under self-defense states that a person may repel force by force in defense against those who intend and attempt by violence to commit him some injury. Christopher Smith did not intend or attempt to harm Antonio Coronel at any time, nor did he use violence at any time on Antonio Coronel. Coronel would have you believe that he needed to shoot Christopher Smith to keep him from pulling a gun. Christopher Smith is a reasonable man. He does not have a death wish. How can you believe that Christopher Smith, a one-eyed man, would have, under gunpoint, turned around, opened his saddlebag with two buckles, opened his saddlebag, rustle around for a pistol, which he did not have, pull out a single-shot pistol, pull back the hammer, aim, and then fire? Christopher Smith would not have tried to shoot a single-shot pistol when all three of the aggressors had rifles trained on him, as you can clearly see in the map that we have presented. If Mr. Smith was truly looking for a fight, why did he not try to overtake Coronel Janssens and Carrillo at a more opportune time, when he still had a gun, for instance? And why did he not fight after he had been shot? Why did he simply run away and do the lawful thing, go get the sheriff and inform him of the infractions that Coronel had committed? Furthermore, Coronel could not have an honest and reasonable belief that he would be harmed. He's obviously guilty. He had the upper hand, and he never warned Smith. He never fired a warning shot. That will be on.
Hey, we gave you time. You're cutting that.
Your Honor, ladies and gentlemen of the jury, my name is Aubrey Valentine, and I'm the counsel for the defendant in this action, Mr. Antonio Coronel. Before we begin, I would like to be sure that we all understand exactly which issue is at hand. We know that Mr. Coronel shot Mr. Smith. The question is, why did he shoot? And after we know that, we have to decide if he was legally justified in shooting, which we, the defense, have proven. I'd really like to state that it is not up to the defendant to prove his innocence. He's presumed innocent until proven guilty beyond all reasonable doubt. The prosecution has just led you to view this entire incident from their perspective. However, each set of facts on which their deductions are based are equally conducive to an interpretation which depicts Antonio Coronel's innocence. Antonio Coronel shot Mr. Smith strictly in self-defense. He had just asked Smith's party to leave and was waiting for a response. Smith did not answer. Suddenly his hand darted away from his saddle horn. Coronel knew that Smith could have been going for a concealed weapon. Not necessarily to a saddlebag, however, as the prosecution leads you to believe. That there happens to be a dip in the saddle, right behind the saddle horn, where there's plenty of room for a pistol, which could have been cocked.
Objection, Your Honor.
That far.
The counsel is...
Sustained.
Wait.
Well, let me continue. We don't care.
There's no testimony about the design of the saddle.
Okay. Come on, Teddy. I'm thinking.
Can I respond to this real quick?
Hurry up, she doesn't have any time left.
I'm assuming the clock has been stopped during first. Responsible not only for himself but also for his two companions, he shot just above Smith's hand to terminate the possibility of being shot himself or his friends being shot. The action was not premeditated, nor was it intended to seriously injure Smith himself. When from the nature and circumstances of a conflict, the defendant has an honest and reasonable belief that an assailant is about to cause him serious bodily injury, he is justified in injuring the assailant in self-defense, even if his belief was wrong. A person has an honest and reasonable belief that his life is endangered when an average man or woman possessing normal judgment and intelligence under similar circumstances would have held the same belief. Edwards fits this description perfectly. They both were there during the initial outburst. They both heard the angry words pass. They both saw the hand move from the saddle horn. They both had the same reaction, which was, we're going to be killed now. The prosecution would like you to believe that Coronel's shot was not provoked by the movement of Smith's hand and therefore was premeditated. They based this on Smith's and O'Leary's testimony that Smith's hand did not move. The honesty of Smith's statement is not in question. It is easy to understand why he said he did not move his hand. Until he was shot, that movement was not that significant. The shot is what made it really important, and the shot occurred after the point in time in which the movement would have been committed to memory. Regarding O'Leary, he testified that he looked at Smith's hand before the shot rang out. However, he did not specify how long before the shot rang out. It takes a split second to move your hand from a saddle horn. Therefore, if O'Leary were to have looked, say, a certain amount, skip that part, okay. Then we have Edwards, totally objective and without bias. He testified that he saw Smith's hand move. He witnessed it move. His hand was not blocked by the horse because your hands when on the saddle horn are on top of the horse. No matter whether you're seeing to the right or left, you can see the hand move. He had absolutely no reason to lie or misrepresent the truth as he stated on the witness stand. The judge will inform you that if ever there are two or more reasonable inferences that can be deducted from any set of facts in this case, the jury must accept the interpretation which depicts the defendant's innocence. Lastly, when Smith's hand was on the saddle horn, it was behind the horse's head and in front of his body. If it didn't move when he was shot, then the bullet would have had to go first through the horse's head and then through him, which it didn't do. Based on all of this evidence, we have to
Objection,
assume...
Your Honor. The counsel is creating a material fact which was not brought out in trial.
All right, I'll take that as submission. Letter from you.
Based on all of this evidence, we have to assume that Smith's hand did move, provoking Coronel to shoot. And since we have heard that Coronel's action was in response to Smith's movement, then Coronel had no way of anticipating the shot could not have been premeditated either. The prosecution also stated that Coronel desired to inflict a bodily injury upon Smith. If Coronel intended to do that, he would have shot Smith in the head or torso, but he didn't. He shot him just above the wrist, just above the hand that would have possibly been responsible for a subsequent injury to himself. If you were to shoot someone, the desired effect of the shot would be in direct correlation with your motive for shooting. The effect of Coronel's shot was that it stopped Smith's hand from moving further, so it's safe to assume the purpose of the shot was to stop his hand, not to injure Smith. Certainly not to kill him. According to the common law doctrine, if in a conflict the assailant, being Smith, is injured, such injury is justifiable and is not subject to criminal sanction. According to the prosecution, Smith and his party were unarmed during the confrontation and therefore defenseless. This statement has no foundation. Coronel ordered them to disarm and they dropped their visible weapons. They had no reason to drop anything concealed. Coronel did not search them. They could have easily still been armed. The prosecution accused Coronel of instigating the conflict by not avoiding it. He could not have avoided it. The aggressor was an unknown.
Objection, Your Honor. This is lack of foundation. None of these facts are rebutted to trial.
You couldn't have avoided it?
Correct. And that was never brought to evidence.
Well, we know
Of course
the
it wasn't brought into
defendant
evidence.
was cut off,
Can't be
so
brought into evidence.
Let her proceed at this point.
It is an obvious deduction from the facts that were brought forth during it.
Your defendant didn't really get to testify, so we'll assume he would have said that.
He could not have avoided it. The aggressor was an unknown. There could have been 20 men. He didn't know how well armed they were, and he did not know what state of mind they were in. He had no way of knowing what he was running from, but for a moment assumed that he did flee. They were after him, and they would have followed until they caught him, whether or not it was on his land. So really, the most he could have done was postpone the conflict, which he did last time he left his camp 2 years ago. So he might have...
Objection, Your Honor.
Is that not an idea?
Sustained.
Oh, this is going to make it evening, okay. So he might as well face the problem and try to deal with it, which he did. He went to the which he did. Note that by the common law doctrine, a defendant is not required to retreat, but may pursue his assailant until he finds himself out of danger. Cornell's state of mind, as well as that of Smith's, becomes even clearer when we recall the social environment. There was a general, unavoidable feeling of malice towards Mexicans throughout California. The Mexican-American War ended just over 2 years ago, but all of the prejudice and hostility which had developed during the war had not simply vanished with the signing of the peace treaty. It was probably worse, since they were now expected to live side by side with each other, with the Mexicans whom they had learned to hate. The year was 1851. It was in the middle of the gold rush. Multitudes of people were moving west to strike it rich, although, remember, a very few percentage actually succeeded, thus spawning a great deal of greed and jealousy compounded with the prejudice. This hostile environment is a major reason for Cornell's extreme caution. Dolores Peterson testifies to Cornell testified to his... Dolores Peterson... Cornell warned... Yeah, okay, moving on. Smith is on the other side of this... He is the prejudiced, hostile American. O'Leary observed a Mexican camp, and as far as he knew, these Mexicans could have easily been American citizens, and if not, they could have already been paying the mining tax. O'Leary and Smith assumed the worst because they were prejudiced. The defense would like to take this time to apologize for their inadequate report.
Jury, we'll discuss that after the jury goes out. Why don't you go out in the hall and close the door behind you and pick one as the foreman and talk about it a little bit and then vote. If anybody's concerned about what the law is, its exact charge, or what self-defense is, instead of reading this to you, I'm going to let you take it. Why don't you take it easy?
And remember, it gives me